Mr. Picciotto.
Good morning, Chief Justice and honorable members of this court. I am the appellant, and my name is Stefano Picciotto. I am here today because I have been deprived of my fundamental rights, due process of law, and equal treatment under the law. I have been singled out for unlawful oppression by the administration of the trial court to deprive me of my property. And it did not just happen once. It happens 2 times through the so-called special assignments. And I've been at it for 7 years, since 1999. Now, I'm here today asking for justice. In defense of their action, the state is saying the GLC 249, Section 4, it's not the appropriate avenue to come to this court. However, they relegated that argument to a footnote. And by the rule of law of this court, in the case of Commonwealth versus Clerk Magistrate of West Roxbury of the District Court Department, which is reported at 439 Mass 352, 2003, they waived that argument. The principal argument that the state has in order to justify its tortious conduct to give me those special assignments, which means special treatment, is that they have a standing order called Standing Order 980, through which the state says that there is language in the standing order that was submitted in the request for special assignment by my opponent that was submitted to the Chief Justice. There is language that states the Chief Justice reserves the right to designate any justice of the court. The request for special assignment that I received does not contain that language, and I have reproduced that for this court as Appendix 17, 18, and 19. I also requested a copy of this request for special assignment, the Standing Order 980, from the administration. And I reproduced it for this court as addendum 2 to my reply brief. What was provided by the administration does not contain such a language. I have seen that language in a publication. However, again, it's relegated to a footnote, and I just was never put on notice that this was the authority of, I was never given due process of law to be able to object to any special assignment. And the first time around, I wasn't even notified at all when Judge Sakura took over my case. In the addendum provided in the appellee brief, which is addendum 1, at page 12, which is in docket entry number 36, says that the other case, the Coolidge-Cascia PC case, remained separate cases from the Nunes versus Picciotto case, which was a declaratory relief case. I never received an opportunity to object, to present my objection to the special assignment of Judge Noni Burns. I never received an opportunity to object to the special assignment of Judge Sakura. And what there has been in my case is an equal application of the laws, which under the rule of this court, under the finding of this court in the Dixon versus Attorney General case, 396 Mass 740, 1986, it's unconstitutional. I'm just entitled to the constitutional guarantees just like any other litigant. The Superior Court has a rotation system, and I should be entitled to the rotation system just like any other litigant. The real issue, however, Chief Justice, is much larger. There is selective application of the regulations and the manipulation of trials for the benefit of insider of the trial court. In 1993, Judge Iso was presiding in Newburyport in the Essex Superior Court. She requested that a very powerful attorney from Hale and Dorr bring the insurance representative into her courtroom to settle my case. This powerful attorney made false statements, which is prohibited by the rule, to Judge Easel. And that's why we've been litigating since then. He said that there was no insurance. That was not true. We know today that that was not true because there was a $9 million settlement. Well, during the bankruptcy proceeding, another very powerful member of the legal firm, a firm, Chief Justice, where you're formally a partner, Chad Holner Stewart, John Nadas, allegedly made some terrible threats against me. That if I wouldn't settle my claims for $900,000, and now the claims have been settled for $9 million, I would be charged with being a pedophile, and my children would be taken away from me. The BBO Chief Justice has done nothing about it, but he's a very powerful member of the legal community in Boston. So what is the reasonable conclusion? Selective regulations. The BBO knows about it. They haven't done nothing about it. Now, during the bankruptcy proceedings, the attorneys that were representing me, they said, you're a crackpot. There is no insurance. There is no bankruptcy fraud. There is no this. They abandoned me. After the $9 million settlement occurred, what happens? They all came in to take the entire $9 million settlement. Not a fair fee. The entire $9 million settlement. The administration gave me Judge Sakura as a special assigned judge without notice and opportunity to be heard. This special assigned judge engaged in some horrible conduct. He allowed the jurors to come dressed in Halloween costumes. He had candies and joke bumper stickers passed to the jurors. There was a joviality throughout the court. There was back-patting of the jurors. The whole case became a free-for-all. But that's not really the worst, Chief Justice. The worst part, in my opinion, is that at the opening statement, the trial counsel that was representing me said, those attorneys came in to take the entire $9 million settlement. Judge Sakura turned around and said, that's not true. It's right in the record that I have prepared in the appendix that I have prepared for this court. And this particular trial counsel has filed an affidavit, and the affidavit is reproduced as 46 to 52 of the appendix. And the offensive statements are reported at 57. Then this trial judge systematically barred all the evidence of the overreaching from going to the juror. At the end of the trial, he imposed a 12% penalty interest on me because I didn't succumb to their unreasonable demand. His friends, his brethren, that's what he used to call them, right in the courtroom, his brethren, unreasonable demands. That's again reproduced as Appendix 46 to 52 and 115 to 117.
Can I ask you, sir, what is the status of that case? Have you appealed that case?
I have appealed, Justice Cordy, I have appealed that case, and I will get to that in 1 second if Your Honor permits me.
Mr.
Mr.
Picciotto, just watch the time, though.
Okay, I paid $50,000 to get the tapes for the trial transcript. Now the tapes are missing, which prove that this judge barred the evidence from reaching the jury. And my question today, Your Honor, is this, very simple. How long do I have to endure this type of insider justice? In a speech that Your Honor made on January 27, 2001, Your Honor said the judicial branch is one institution that cannot afford to fail the public. Am I not a member of the public? Your Honor, further stated, a fair and equal treatment before the law, it's important for every litigant. How can Your Honor tell me today that I have received fair treatment under the law? Thank you for listening to me.
Thank you, Mr. Picciotto. Ms. Liddell? I'm sorry, Ms. Martin.
Yes. Good morning, Your Honors. Mary Ann Reynolds Martin for the Honorable Barbara J. Rouse as Chief Justice of the Superior Court. Initially, I'd like to draw your attention to the appendix to the brief for Mr. Picciotto. And on page 32 of the appendix, you'll see that he did indeed have notice and opportunity to be heard on the request for special assignment. The appendix contains his letter, which is written in pursuant to Standing Order 980, in which he discusses his position on the request for special assignment. And in the standing order itself, it refers to, in standing order itself in paragraphs 2 and 3, as well as others, it refers to Request A and Request B, which are annexed to the standing order. So the standing order...
Ms. Martin, I don't wish to interrupt you. I think the justices are probably familiar with the provisions of the standing order. If there's a particular aspect of the appendix that you wish to draw our attention to, that would be helpful, but I think we are familiar with the provisions of the standing order.
Thank you, Your Honor. My point being that the standing order that Mr. Picciotto has referred to is incomplete, which is self-evident on its by the reference to the attachments, which he does not acknowledge when he says that the Chief Justice has not reserved to herself the right to specially appoint any justice that she may, of the court, that she may seem fit to do. General Laws, Chapter 211B, Section 10, as well as the Superior Court Standing Order 980, authorize the Chief Justice to assign judges to hear actions in Superior Court. There was no error in exercising that authority in this case. And in light of appellant's opening arguments, I would like to make clear that any reference that I do not make to any proceedings other than the question of the propriety of this standing order is not to be deemed as any admission of any accuracy of what he said. It's merely
No, of course not. It's argument. We understand that.
Yes, and this matter that's before you is limited to review of the special assignment order. It doesn't include review of any other issues that he may be involved with in other pending dockets. There was no error in exercising authority to assign a special justice in the underlying action. Indeed, it is not even established that the Chief Justice assignment of a particular justice is reviewable under Chapter 249, Section 4. In any event, in this case, if Mr. Picciotto believes that the assigned justice is not able to render to him a fair and impartial determination, his remedy is available, and that is to move for her recusal. A recusal motion has indeed been made, and it was denied, and that issue is now preserved for appeal upon entry of a final judgment, at which time the reviewing court can look at the entire record to determine if there was a basis for recusal, and therefore due process is fully satisfied. Appellant, like all litigants, simply has no right to control the assignment process of judges in the Superior Court. He might prefer the rotation system to be employed in his case, but Standing Order 980 clearly establishes a special assignment process for civil actions, and that process was followed without error or abuse of discretion, and there is no equal protection violation.
Do you know whether or not there have been any special assignments made in any other cases?
Well, yes, there have been other special assignments, and in fact, Mr. Picciotto referred himself to one in an earlier litigation.
I mean, is this something that occurs, is it rare or does it occur often?
Unfortunately, I don't have statistics for you on how often it's made, but it's very clearly a process that's provided for and authorized by the Rules of Civil Procedure, which I cite in my brief, Massachusetts Rule of Civil Procedure 83, which allows standing orders like this one to be promulgated and approved. But if you would
if
like...
I could just rephrase, not rephrase, but ask a supplemental question with respect to special assignments under standing orders, which are not requested by one or other party. Who requested in this matter?
In this particular matter, it was a plaintiff named Juan Nunez, where Mr. Picciotto is a defendant in that case.
And that's the standing order that's at issue here?
Yes.
Okay, thank you.
Mr. Nunez requested a special assignment for his particular case, and his particular case was consolidated with another case, all referred to, all the docket numbers are in my brief, where the plaintiff was a law firm. The law firm opposed Mr. Nunez's request for special assignment, not on the basis that there should be no special assignment at all, but on the basis that to just have a special assignment for the Nunez case would defeat the purpose of consolidating Nunez and the law firm's case, and that what the Chief Justice did then is when she ordered special assignment, she ordered it for both cases.
Ms. Martin, which was that law firm? Which law firm was that?
It's Krulwich.
Okay, fine.
And so,
do you happen to know, and if the answer is no, that would be fine, do you happen to know whether Choate Hall and Stewart was involved in any of these proceedings?
yes, I do know, and yes, they were. They
Okay.
filed an opposition to the petition for cert filed by Mr. Picciotto before the single justice. They have not, however, continued to involve themselves in this further review of that decision.
Thank
The
you.
docket in the single justice case will show their opposition being on file. If there are no other questions, I would like to then rest on my brief and ask that you...
Can I ask you one question? And again, you may not have an answer to this. Mr. Picciotto has mentioned that the record or transcript or tape, I'm not sure how they took the record of the main trial, is missing. You don't know anything about that? Has a complaint been filed with the Chief Justice about the availability of it? This is the trial before
okay. Yes, no, I understand.
Judge Sikora.
I want to answer your question, but first with a disclaimer, which is that that question goes to a docket that's not actually before you, but I understand Mr. Picciotto has raised it to your attention.
Well, you make the very good point that he's filed a motion to recuse. All that can be reviewed on appeal, but
No.
I'm curious about his main appeal, and if there's no transcripts of that, that sort of undercuts that right quite a bit.
Right. His main appeal that he referred to, where he alleges that there are portions of the transcript that are missing, and is an appeal of the trial. Apparently it was a 60-day trial before Judge Sikora, and it's an appeal of that. Just for purposes of clarity, it's my understanding that that trial did not resolve all issues of dispute between a number of the parties, and that's why we have these other pending cases at different dockets before a different judge. And it's those different dockets before a different judge that I'm here before you on this morning. But as to matters I'm not here before you on, just because there is, I did acquaint myself as much as possible with the facts to aid in evaluation of this case as well as to assist the court this morning. It's my understanding that the status of that appeal is that the record is in the process of being assembled and has not yet been actually filed. So there is the possibility that Mr. Picciotto is correct, that there may be portions of that transcript that are missing. I noticed in his reply brief he's attached an affidavit from the court reporter in that matter, but I am not here before you to...
No, I understand.
That's fine.
So you say it was a 60-day trial?
Apparently, yes.
Do you know whether there were multiple reporters, many different reporters in the case?
No, I do not know that, again, because that matter is not directly pertaining to the matter before the court this morning, because this has to do with issues not addressed in that trial and the assignment of a judge for disposition of those issues.
Thank you, Ms. Martin.
Thank you.